the conference committee meeting on House Bill 9 to kind of resolve some differences in the two bodies. Let's call roll just to be official on this thing. Can we do that?
Here. Here.
Here.
Here. And Senator Nethercott excused and Representative Washington excused, right? Okay, so Representative, you offline were beginning to bring us up to speed on concerns that you have for the language in the Senate version, which includes under the age of 21.
The House deleted that language.
And the House had different language, which had 18 and over, okay, essentially. So as to concurrent jurisdiction. So Representative, would you mind walking us through your thoughts as to, because Senator Kinski was not here earlier offline.
Thank you, Chairman Landon. So to be clear, am I correct in this, that what you did is
Like this is the original, okay?
the Senate, in essence, deleted the amendment that we added. And it is that, do you think that's accurate, Senator?
Yes. So Representative, I brought the amendment that we ran on a committee of the whole after working that in committee, and it deleted under the age of 21 and inserted age 18 and older. No, that's the House amendment. No. That is the amendment that we put on right here in front of us. So this is the original language. An adult is alleged to have committed a criminal offense or to have violated a municipal ordinance while the adult was a minor. And what we
It's
did,
been changed to,
it has been changed to an adult who is under the age of 21 is alleged to have committed a criminal offense or to have violated a municipal ordinance while the adult was a minor.
Correct. So if I may, so what that is, and in conference committee, we worked from the engrossed copy. So what we're looking at includes that, who is under the age of 21, which was a standing, or was an amendment from the House. And so that's what we're conferencing about is simply that, whether that language of who is under the age of 21. So it greatly narrows the scope of what adult means in this context. So what I'd like to do is run through the thought of that. So first of all, the entire bill, the point is there was a case in the Wyoming Supreme Court where the offender was 17 and charged at 18. So the district court found that the juvenile court did not have jurisdiction, and the Supreme Court overturned that and said the statutes were vague, but how we read it is that it's at the age of the person committing the offense, so that the juvenile court would have concurrent jurisdiction. So what we're looking at here is making that clearer in our statutes, okay? But if you actually look at the case that it came to us via, which was Rosen v. State, and specifically in it, there's a footnote that the Supreme Court wrote, footnote 5, and it says, both cases that the state addressed were circumstances where the person charged after reaching the age of 21 for crimes committed as a child. That is not the circumstance here. Mr. Rosen was charged when he was 18, an age over which the Juvenile Justice Act contemplates juvenile court jurisdiction. But again, so they put the sideboards, this next sentence. This case does not present a question of the juvenile court's jurisdiction over a person who commits an offense as a child and is charged after he reaches the age of 21, and we therefore will not address that question. So we were looking at trying to put in our statutes to clear it up based via this Rosen v. State case. However, I personally think we're going too broad by not addressing this age of 21. And I arrive at that from experience that I have working with these cases and looking at the reality of it. So first of all, I think, so to start out, if you're charging somebody who's 25, 27 years old, there isn't anything that the juvenile court is truly going to be able to do with them.
Even if they committed the crime when they were 21 or 20?
Yes, 20. 20 would be included in this. This is 21 and older.
Okay.
So a lot of times, like I say, you're looking at this older offender. Well, you can't be in the boys and girls schools past the age of 21. You can't do, so it just becomes rather superfluous. There's not a rehabilitative procedure to deal with adults past that age. So I think it creates that problem. And then also I think then when you look at it from a practical standpoint, I can tell you that you're usually looking at very, very significant crimes that happen if somebody's being charged 10 years later for any crime, let alone something that happened when they were a juvenile. And so it would largely probably be charged for something that that is probably maybe a continuing danger to the community. I think one of the most often would probably be crimes of like sex assault, where there would be a concern perhaps like that this person was a true pedophile. And for public safety needs to have rehabilitation, needs to have those things. And so I think from a realistic standpoint, there's that, but I also think this, here's another thing to understand with this. The county attorney or the district attorney has the authority and the discretion to choose where to charge anyway. So these cases that they're doing 10 years later on a 27-year-old, they're going to choose to charge as an adult. And all you're going to do is create a needless hearing, I would submit, via these transfer hearings, because, and this is why that it kind of conflicts with, there's factors for a transfer hearing. And this is an important one that, again, I think makes sense that it should be 21 or older. So one of the factors for a transfer hearing includes that the prospects for adequate protection of the public and the likelihood of reasonable rehabilitation of the juvenile if by the use of procedures, services, and facilities currently available to the juvenile court. The answer is there aren't those services and programs and procedures via the juvenile court for somebody who's a full adult. So you're going to win the transfer hearing, but without us setting what I think are the proper sideboards, you're just creating a situation where you're going to be having a needless transfer hearing. And then, so finally, looking at the two cases that, like this, the state did use in this Rosen, where the Supreme Court said those are cases where they're over 21, so we're not going to look at those. One of them, United States versus Who, which was in the Second Circuit Court of the United States Court of Appeals, and they actually quote the juvenile, the federal juvenile, and it says that 18 U.S.C. section 5031 says, for the purposes of this chapter, a juvenile is a person who has not attained his 18th birthday, or for the purpose of proceedings and disposition under this chapter for an alleged act of juvenile delinquency, a person who has not attained his 21st birthday. So something similar, maybe wordier, but something similar to what we're looking at here.
So can you help me? If they're 18 and under, they're a minor? Or is it if they're on their 18th birthday, you're no longer a minor?
Yes, I would say that's correct. On your 18th birthday, you're no longer a minor or a child.
18, you're a minor. If you're 18 to 21, you are still, what are you? You're an adult, but a minor?
Okay, so I would, this is what I would say in our law, you are an adult. So for purposes of the Juvenile Justice Act, how it's defined, and it's used child and minor, and it's somebody who's under 18.
Okay.
So, and we would still be looking at that, and that what this addresses is for when a minor commits an offense. So these are for offenses committed when somebody was a minor, under 18. This next step is about when they're charged and how they're handled. So we start out with, they committed it when they were under 18. They were 18 or under, I should say. No, well, under 18. Then this allows them as an adult to have concurrent jurisdiction with the Juvenile Justice Act through the age of 21. But it puts the sideboard as far as being 21, not through a 40-year-old that we would charge as a juvenile, which.
Okay, so bear with me, because this is all new to me. An adult is alleged to have committed a criminal offense or to have violated a municipal ordinance when the adult was a minor. That means juvenile court and municipal court both have jurisdiction? Concurrent jurisdiction applies then? An adult is alleged to have committed offense, so they're 18 now, but they committed it when they were 17. We're trying to clarify whether that should be in municipal or juvenile or both?
No, what that's referring to is the type of offense that they would have committed. And basically, it's so whether you committed a crime that would go to circuit court, municipal court, or district court, they could be charged with it, they could be charged under the juvenile, as a juvenile.
Okay. So originally it said an adult is alleged to have committed. The Senate changed it to an adult who is under the age of 21 is alleged to have committed.
So, thank you, Madam Chairwoman. The House put in the Judiciary Committee, we amended in that age of 21 language. So originally, we did not decipher between the age of what the offender was, which is why I voted against the bill on third reading, because this amendment, I think, it rubs against the Rosen case, particularly given the interim. I had some vague recollection and went back to look, and the conversation during the interim was that we shouldn't maybe necessarily do this because the entire Juvenile Justice Act and many of our statutes that consider minors as criminal offenders has concluded that it's the juvenile court's jurisdiction depends on the offender's age at the time the offender commits an offense, which we see throughout our statutes that relate to juveniles. And then part of what my concern was that I think may have been brought up in some of the discussion in judiciary over the summer was, if we're going to consider it based on when the offender is charged, so an act happens when the offender's, say, 15, our statutory sexual assault laws have the age of which an offender has to be before it's, I believe, like first degree of that nature, right? So what's in question is the age of the offender at the time that the crime was committed. If we wait and then we say, okay, well, we didn't have enough evidence or whatever, or we didn't know about it until this person was an adult, then is that rape charge becomes something different entirely, because, or that would be the parallel, I think, with what we're doing. If we keep it, we're gonna have different tiers by the age of which the person accused is at the time we charge them.
So I'm not afraid to say I'm hopelessly lost.
That's fine.
But let me ask, are we agreed on the outcome or do we differ on the outcome? In other words, we're talking about somebody just turned 19, but when they were 17 and a half, they had sex with somebody 2 years younger than them. Oh, 3 years younger than them. And so are we agreed that that should go to juvenile court in the district court? Do both of you agree that that's the outcome we're looking for, or no?
No, I don't agree, because in the case, the example you just gave, either way, this would give concurrent jurisdiction, and currently as our statutes are written, to be honest, as far as the Rosen case is concerned, but that could be taken, that could have concurrent jurisdiction between the district court and the juvenile court, and could be charged either way with the
Okay.
district attorney. So what this amendment does is about when they're over 21, just saying that the juvenile court does not have concurrent jurisdiction over when over the defendant when they're over 22. And it's as simple as this. I think it creates extra, like superfluous hearings and extra things because that aren't going to lead to a productive result, because the reality is the juvenile court and the juvenile services and procedures are not set up to be able to handle these
So
over
what's at
21.
issue is they're over 21, charged with a crime committed when they were between 18 and 21?
No, it would be. Madam Chairwoman, so it would be if the act was committed before they were the age of the majority. So,
Which is 18.
yes, so up until the day before you turn 18, you're considered a minor, and that is when. So if you commit a crime at 19, you're an adult. We're no longer considering you as a juvenile in any regard. So what that amendment does, and I understand the concern that Representative Oakley brings, which is anybody over the age of 21 can't necessarily be like, go through juvenile services because we can't send them to the boys' school and so forth. But the concern that I had, that I think was discussed during the interim, was it's supposed to be about the age at which the act occurred. And so what happens then if we're holding youth to a different standard for a very specific, for a very real reason? Does it make sense to then come back 5-10 years later and say, we're going to hold you to the standard that you're at right now?
And if I may respond to that, so I'll start in a similar vein that Representative Provenza just went. So it is already current law that if you do an offense under 18, you're a juvenile. That's defined. So that we're not changing that here. This is about if you are charged when you are an adult, which means over 18, and at what level the juvenile court would have
Still comes into play.
concurrent jurisdiction. Okay, that's all this is. So that's what we're adding. That was what we were meaning to add via the Rosen case. I brought this amendment, actually, because I think it's too broad. I don't think it fits the reality. I don't think it fits how courts work. So I think it is appropriate. I personally think it is appropriate, and it fits statutes that we have. It fits federal law, and that we would allow that 18, 19, 20-year-old who's still young, but over the age of majority, for that concurrent jurisdiction. But the idea that we would allow that from 21 to 90 just creates a relative absurdity, I would say. And also, it's just not how the practice works.
So how does the amendment fail to, how does the amendment fail to capture what you just
So,
described?
Madam Chairman, that was going to be my question, because as you read this, the intent of the Senate, I believe, was 21 and under are going to, that's where this concurrent jurisdictional issue comes into play. Above the age of 21, it just never would, according to the way I read this, but maybe I'm reading
Senator,
the amendment wrong.
what you're getting wrong is this is the engrossed copy. We added the under the age of 21, and the Senate struck it.
Okay.
So your amendment was to create what I'm arguing about is the absurdity of having these older adults charged and allowing concurrent jurisdiction with the juvenile justice and with the juvenile court. That's what the Senate did, is took out our amendment that added this sideboard for 18, 19, and 20-year-olds to be included, but excluded 21 through 90.
I had them flipped.
Right.
Okay.
So if you're agreeing, then you're on our side. But I wanted to address something that Representative Provenza said, and welcome Chairman Washut to the I know you had a long,
Apologize, overlapping meeting.
no worry, I know you were worried you were in a long conference committee. But so I wanted to address something that Representative Provenza said, and this still goes back to what I've been saying, which is if they're serious offenses, they are, the county attorney or the district attorney already has the ability to charge them as an adult, and that's going to be the realities of how this goes. So if it is a first-degree sex assault, let's say, or sex assault of a minor, and there's a concern that the defendant is a pedophile, they'll be charged as an adult. And then I think it creates, again, this sort of idea that the defense attorney can then put in for a transfer hearing. I think one of the factors alone that says that you have to consider what the juvenile court's ability to rehab would be to the person. And the answer is nothing when they're of this age. I mean, even that alone, I think, points towards putting this sideboard at 18 to 20. I would point out also in Title 14, for example, probation. So 14.6.247, so in our Juvenile Justice Act, it says, and this is in regards to probation, but again, there's a very similar sideboard. If the juvenile court places a child on probation at any sanction level, the juvenile court shall discharge the child from the custody of probation on the date the provisions of this section are met or on the child's 21st birthday, whichever is earlier. So, for example, in our statutes, there's a mandate that they take a person off of a juvenile probation on their 21st birthday. What this does is make our statutes cohesive in that way, that already our Juvenile Justice Act anticipates having 18, 19, and 20-year-olds. It does not anticipate, I would submit, having 21 and older. You can't be at the boys' school, you can't be on probation, you can't be, so I just think this is a necessary sideboard.
So Representative, let me make sure I understand. In all these instances, we're taught, throughout this entire discussion, we're talking about a crime that was committed while they were under 18.
Correct.
Okay. And so if they were under 18 and they were charged when they're under 18, that's easy. If they were under 18 and they're charged when they're over 21, where do they go?
That's what we're discussing.
Okay.
And I would submit that we don't want to include them, that they could be handled via juvenile court in that instance, that it's an absurdity.
Okay, but if they're under 18 when the crime is committed, and they're between 18 and 21 when they're charged, we're cool on that one.
Yes, well, that's, in a way, that's what we're deciding and that we're putting into statute here, is that indeed, we are saying that the juvenile court would have that concurrent jurisdiction.
Okay.
Which basically, in the Rosen case, is what the Supreme Court found, which is originally what we were trying to do kind of as a cleanup, because they said it was vague, but we find that it's this way. So basically, this puts into statute what the Supreme Court says our laws are at anyway.
So Representative Provenza, do you agree with that if they commit the crime under 18, they're charged when they're between 18 and 21, juvenile court should be concurrent?
Thank you, Madam Chairwoman. So I don't necessarily agree that we should do this with that 21 age because of the conversations we had in the interim, and because I think it flies in the face of what our juvenile justice statutes do, which is to consider the age at which a crime was committed. And so I understand the concerns about the where we send them, but they can be tried, we can still try them as adults, we can still move them to adult court, and then we don't have to deal with that. So with these serious cases, that's what's gonna happen anyway. It can be moved. This, in some ways, takes away discretion of the court to make that decision to say, okay, well, we know this person is after the age of majority at 20, 22, whatever. They committed an act when they were 16. Does it make sense to go after them as if they were an adult at the time? I just think it flies in the face of Rosen and also the the Juvenile Justice Act. So that's the main reason, that's the only reason why I voted against this bill. I was in full support of the bill coming out of the interim as it was, and this amendment gave me heartburn.
So let's take that fact pattern. The guy is, he's 23. It's discovered that he had, committed something that's serious well under 18. Not so serious. They could be charged adult, but the prosecutor's saying, why would I do that? I mean, we've got a plea agreement worked out. Let's just put it in juvie and take care of it. And you're saying it just shouldn't be, 21 and older just shouldn't be in there at all.
Senator Kinski, yes, I don't think that should be, and it's because of, all I can say is from a practitioner's standpoint, overwhelmed with work as we are, the cases that we are looking at, that you go back years later and charge are serious offenses. And the idea that the juvenile system can do anything, like, you wouldn't go back and charge because there'd be no point to charging somebody as a juvenile. There's nothing that can be done with them. They can't be on probation.
'Cause they're
They
23,
can't go,
yeah.
right, so that's what I'm saying, is it just makes so much more sense with things that are in statute already, with the realities of that, we end that, we end those processes and procedures
So which
for when
language-
they're 21.
Which language set produces the outcome that you're talking about?
The amendment that the House passed, which is the engrossed, which is, I can give it to you, there's the engrossed copy, which is what passed the House, which
An adult who
includes the
is under age of
sideboards.
21 is alleged to have committed a criminal offense, violated while adult was a minor.
So, Madam Chairman, so the only slight push that I would give to that is all those years that I served in the administration at a college where we had 21 and 22-year-olds around. And that's what got the conversation started about there still might be relevance in concurrent jurisdiction. And the senator just touched on it. I get what you're saying, which is there really isn't any reason to allow it to go to juvenile court, although it would still go on the record, would it not?
No, then it would be, there's a whole different set of,
Then it's expunged or whatever.
Right.
Hidden, whatever.
and so I would say, what would a prosecutor bring a case for that you can't put them on probation, you can't sentence them to, and it's not going to be on their record. I mean, it's if that decision is made that this 22-year-old did something when they were 17, it's 5 years old, nobody's going to go bring up a case that's 5 years old unless it needs dealt with because it's a serious offense. And
Gotcha. I got you now.
Okay.
and so you're not going to bring something that's a serious offense that's 5 years old and then have literally no options to do anything with them in this juvenile, in the juvenile court. There's nothing that can be done. So the only time you're gonna do that is bring a serious offense, in which case the prosecutor already has the discretion to charge, and they're going to win a transfer hearing after doing a superfluous hearing because we didn't set enough sideboards, in my
Right.
opinion.
So regardless of whether it's a very young 21-year-old, this dates back 4 years previous where he or she really stepped out of bounds. I mean, big time.
And would have been
Otherwise-
charged as an adult anyway.
and-
Okay.
and
That's
so-
what I'm saying, the practicalities of this or
So
that,
the
yes.
engrossed version basically said, no, we'll give you till 21.
Right. And then
And then
we,
after that, adult only.
correct, and who knows if that's the right sideboards, but I can tell you this, it already is replete in our law to have these 18, 19, and 21 year, 18, 19, and 20 is kind of this, is that buffer period that exists in a variety of ways, I would argue, in our laws, anywhere from, drinking and different things, but also as far as probation, as far as what we can do with them in the juvenile court system, it ends at 21.
So if we create concurrent jurisdiction, it seems to me that you just create the likelihood that you're going to have a juvenile court hearing where the juvenile court judge will say, there's nothing I can do with this case, right? So why do the hearing at
what she
all?
had talked about.
Yeah, why do the hearing at all if there's nothing you can do with it?
Okay, so, Madam Chairman, I regret that we're going to run out of time. All 5 of us need to get upstairs fairly directly because we'll all gavel in. We may have to gather to finish this up again. What say you?
I think, it might have taken us a little longer to get there with the understanding, but I think everybody understands now, and I think everybody, I know Representative Provenza is very, understands this very thoroughly, and does a great job. I know our chairman does. I think you two are on board, so unless we think there's a need to wait for Senator Nethercott, I would say we go forward.
Come back to it on Thursday, maybe?
Let me say this, I'm ready to recede from the Senate's amendment, but I do feel an obligation to sit down with LSO and just make doubly sure that I'm tracking.
That's kind of where I am, Madam Chairman, and also just to bring our other senator into the fold,
She might have some real strong feelings one way or the other.
yeah, and if she feels strongly one way or the other, we need to know that. It looks like the chairman is good with, if we were to come back to the engrossed version, which is the House version, if we're going to take that whipping, Senator, I think we just need to double check, and then we can maybe get back together tomorrow at some point and sign it. What do you think?
Yeah.
Does that sound okay to everyone? Madam Chairman?
Yes, that's fine. And we can talk whether we need to set another one of these or we can concur. But I just wanted here, I've got it handy.
might be
So
able to-
here is Chairman, Washat's our committee. I think, was it a committee of the whole or just a?
It was a
Standing committee. But so very clearly, we, and of course, we discussed it, but we added this language. So this is the House position. Do you want that, Senator?
Yeah, thank you.
You know what, I misspoke, we can't recede, we don't have the bill in our possession. We can only recede from our amendment if we have the bill in our possession, so we'd have to do a conference committee report.
Okay.
So I'm ready to sign on to the House language, subject to, we want to speak to Tara and also make sure I'm clear with LSO what I think I'm clear on.
Yeah,
Sounds good.
thank you, Senator. We've got a conference committee report this.
Yeah, okay.
We do have a pretty full agenda in the morning, however, so if we're going to get together tomorrow, maybe.
Yeah, we've got to build up, the final one we will consider for your side, so we'll get together and chances are we won't have to meet again, Madam Chairman.
Okay.
We'll try to get that signed in the hallway because I think you have 2 senators coming in your direction and we just want to touch base with a couple of people. Okay?
Okay.
All right.
Thank you.
Thank you, guys.